Hello, and welcome to this deep dive. If you are listening to this, you are preparing for the MBE, the Multi-State Bar Examination.
Which is, a massive undertaking.
Oh, it really is. And we know that for you, our listener, English is actually your second language. So you're not just tackling complex legal concepts, you're doing it in a whole different language.
That takes an incredible amount of focus.
It does. So our mission today is very specific. We are going to take the incredibly dense, complex legal doctrines of contractual discharge and excuse, and we're going to break them down into very simple English.
Right, because the bar examiners love to hide the ball with big vocabulary words.
Exactly. We're going to make sure you cover every single detail,
Yeah.
translate the jargon, and give you the tools so you can just crush this exam. So, okay, let's unpack this. I think we need to start right at the foundation.
Yeah, that makes sense.
What does the word discharge actually mean when we are, looking at a contract?
Well, discharge is just a fancy legal word for being freed. It simply means that a promisor, and that's the person who made a promise, is no longer legally required to perform their duty.
Right. The legal chains are off.
Exactly. You are free to walk away, and you cannot be sued for breaching the contract.
Okay, but why does this happen? I mean, a contract is a promise, right?
It is, but the law allows a discharge because of what we call a supervening event.
A supervening event. Let's define that for our listener.
Sure, supervening is just a really technical way of saying a big unexpected change that happens after the contract is signed.
After, that's the key word, right.
Yes, you sign the paper on Monday and the world is normal. Then on Wednesday, a supervening event happens, like a hurricane or a new law is passed.
And because the world completely changed on Wednesday, your promise for Monday is it's discharged.
Right. It wouldn't be fair to force you to perform when the reality of the situation is completely different now.
Got it. Now, for the MBE, we need a way to remember all the different ways a contract can be discharged.
And we are going to use mnemonics. Mnemonics are basically just memory tricks, like acronyms, to help you look in the rules.
Right, and we will always use mnemonics today. So what is our master mnemonic for the 5 main ways a contract is discharged?
It is F-I-I-R-R. We pronounce it like the word fire.
F-I-I-R-R, fire.
Exactly. The letters stand for frustration of purpose, impossibility, impracticability, rescission, and release.
Okay, F for frustration, I for impossibility, the other I for impracticability, R for rescission, and the last R for release.
You've got it. That's the whole map for this deep dive.
And to our listener, don't worry if those words sound confusing right now. We're going to break down every single one, and we'll do frequent rapid-fire recaps so they stick in your brain.
Perfect. So should we start with the first I in our fire mnemonic?
Yes, let's do it. Segment 1, the first I is for impossibility.
Right. Now, the definition of impossibility is that performance has become impracticable because of extreme and unreasonable difficulty or expense.
Wait, hold on. Let me stop you there. Because the law is doing that thing again.
Doing what?
Using confusing words. You just use the word impracticable to define impossibility. But we have another category called impracticability.
I know. It is very annoying. The terminology is messy.
For our listener, especially with English as a second language, let's make a really crucial MBE distinction right now. What is the difference between objective impossibility and subjective impossibility?
This is the most important rule for this section. Objective impossibility means the thing cannot be done by anyone, anywhere, at all.
Anyone in the world.
Yes. Subjective impossibility, on the other hand, means I personally cannot do it.
Okay. And which one is the actual legal defense?
Only objective impossibility works as a defense.
Let's use an analogy to really cement this. Say, I promise to paint your house next week. We sign a contract.
Okay, standard contract.
But over the weekend, I fall off a ladder, and I
Right.
completely break my right arm, my painting arm. I physically cannot paint your house. Is that contract discharged?
No, it is not discharged.
But it's impossible for me.
Right, it's impossible for you. That is subjective impossibility.
Mhm.
You breaking your arm doesn't mean the house can't be painted. The house is still there. Someone else can still paint it.
So the law basically says, that's your problem. Go hire someone else to do it for you.
Exactly. You still owe me a painted house. Now, how would we change that analogy to make it objective impossibility?
Well, what if instead of me breaking my arm, your house gets struck by lightning and burns completely to the ground? It's just a pile of ashes.
Yes. Now nobody can paint it.
Right, because nobody can paint a pile of ashes.
Exactly. That is objective impossibility. The subject matter is gone, so the duty is discharged.
Okay, that makes perfect sense. Objective means no one can do it. Subjective means just, I can't do it.
Right. And to help the listener remember exactly when objective impossibility applies, we have a submnemonic.
Excellent. More mnemonics. What is it?
It is IDI.
IDI. What are the three triggers of impossibility?
The first I stands for illegal.
Illegal. So performance becomes illegal after making the contract.
Yes. Say you contract to sell a specific chemical. The next day, the government passes a law saying that chemical is completely banned.
Ah, so it's objectively impossible to sell it now without going to jail.
Exactly. The contract is discharged.
Got it. What does the D stand for?
D is for destroyed.
Like the house burning down.
Yes, the specific subject matter is destroyed. But the key word is specific.
What do you mean by that?
If you promise to sell me a 2015 Honda Civic and the one on your lot gets crushed by a tree,
That's destroyed, right?
well, yes, but not the specific subject matter because you didn't promise me that exact car. You can just go buy another 2015 Honda Civic and give it to me.
Oh, wow. So because any Honda Civic will do, it's not objectively impossible.
Right. It's only destroyed if we contracted for, say, a specific custom-built car with a specific VIN number.
That is a tricky exam note. Okay, so I for illegal, D for destroyed. What's the last I?
The last I is incapacitated or death.
Wait, didn't you just tell me that breaking my arm doesn't count?
I did. This trigger comes with a huge warning label. Death or incapacity only discharges the contract if it is a personal services contract.
Let's translate that. What is a personal services contract?
It means we hired someone for their unique, special skills.
Like, if I hire a famous singer for a concert.
Exactly. If the famous singer gets sick, no one else can sing like them. The contract is discharged.
But this brings up a trap I saw in the sources, the delegable services trap.
Yes.
What if the contract is just to perform standard services that anyone could do, like mowing a lawn?
Then it is not a personal services contract. The service can be delegated.
Delegated meaning given to someone else to do.
Right. If Bob, the landscaper, gets sick, Bob's company can just send someone else to push the lawnmower. The contract is not discharged.
So unique skills equal discharged. Standard labor equals not discharged.
You nailed it.
Okay, before we recap, there's one more term in this section. Quasi-contract recovery.
Yes.
Let's explain quasi-contract in simple English for our listener.
Quasi basically just means like so a quasi contract is like a contract.
But it's not a real one we signed.
Right. It's a rule the court makes up after the fact so things are fair.
Give me an example of when we need this fairness.
Sure. Let's say I hire you to build me a custom boat. Halfway through, you spend a lot of money and time working on it.
Okay, I'm working hard.
Then a storm destroys the boat completely. Objective impossibility. The contract is discharged.
But wait, I just lost all the money and time I put into building the first half.
Exactly. Under the formal contract, you get nothing. But that's not fair.
Right, that's incredibly unfair.
So the court uses a quasi-contract. They say, even though the real contract is gone, we are going to force the buyer to pay you for the benefit you already provided before the storm hit.
Oh, that makes sense. It just keeps one person from losing everything while the other person walks away clean?
Yes. The performing party gets paid for the work they already did.
Awesome. Okay, listener, here is recap checkpoint 1.
Let's lock it in.
For impossibility, the rule is objective versus subjective. Only objective works, meaning no one in the world can do it. Remember your IDI mnemonic: illegal, destroyed, incapacitated. And remember, incapacity only works for unique personal skills, not simple jobs like mowing a lawn.
Excellent summary.
Let's move on to segment 2, the other I in our fire mnemonic. Impracticability.
Right.
So impossibility means the subject matter is destroyed or illegal. But what if the subject matter is still there, but doing the job has just become a total nightmare?
That is where impracticability comes in. This defense is used when performance isn't impossible, but it's incredibly burdensome.
Extremely hard to do.
Very, very hard and expensive.
But again, the bar examiners need strict rules, not just feelings. So we have another mnemonic for the 5 elements of impracticability.
We do. And this mnemonic is UBINN.
UBINN. You
Now-
can imagine saying you've been in no nonsense to remember the letters.
That's a good way to remember it.
So what does the U stand for?
U stands for unforeseeable. The event that caused the nightmare had to be a total surprise.
Give me an example of what is not a surprise.
If you promise to ship goods across the ocean during hurricane season, and there is a hurricane,
Yeah, that's not a surprise. That happens every year.
right, the court expects you to plan for that. An unforeseeable event is something completely wild, like a sudden outbreak of a brand new war that blocks a major global trade route.
Got it. Okay, the B in UBIN.
B stands for basic assumption.
That sounds complicated. Let's translate that.
It just means that when you made the contract, both people assumed this crazy event would not happen.
So it's like an unspoken rule of the deal.
Yes. The contract was built on the foundation that this surprise event wouldn't ruin everything.
Okay, U for unforeseeable, B for basic assumption. What's the I?
I stands for impracticable.
Meaning the event actually caused the extreme difficulty.
Right. It didn't just make things a little bit harder, it made performance commercially ruinous.
Okay, now we have two N's. What is the first one?
N stands for not at fault.
The party asking for the discharge didn't cause the problem.
Exactly. What's fascinating here is how the law balances fairness. You can't just claim a job is too hard if you were the one who messed it up.
Right, like if I accidentally burned down my own factory, I can't say, oh no, it's too hard to make the goods now.
Exactly. You caused it, so you are at fault. You don't get the defense.
Makes perfect sense. And the last N,
N stands for no risk borne.
no risk borne. Let's break down borne for our listener.
It means you didn't agree to carry the weight of that specific risk.
So I didn't sign a contract saying, I promise to deliver these goods even if there is a massive war.
Exactly. If you specifically promise to take on that danger, you have borne the risk. You can't use impracticability to get out of it later.
Okay, time for recap checkpoint 2. Listener, listen closely.
This is impracticability.
When doing the job is not impossible, but extremely hard, use UBINN. U is unforeseeable, it was a surprise. B is basic assumption, you assumed it wouldn't happen. I is impracticable, it actually made things too hard. N is not at fault, you didn't cause it. N is no risk borne, you didn't sign a paper accepting the danger.
That's perfectly stated. Simple English.
Thank you. Let's keep moving. Segment 3. This is the F in our FIRE mnemonic.
Frustration of purpose.
Right. So impossibility is when you can't do it. Impracticability is when it's too hard to do it. But what if you can still perform the contract easily, but the whole reason you made the contract in the first place is completely ruined?
That is frustration of purpose. The unforeseen events arise and they make the contract pointless. Pointless. The why disappears.
Yes. And when this happens, the frustrated party can rescind the contract.
Rescind. Let's define that legal term for the listener.
Rescind simply means to cancel or tear up the contract. You walk away without paying damages.
To make this super clear, the source material gives us a great example, the condemned building example. Let's talk through it.
Absolutely. So person A makes a contract with person B. Person A is going to buy a commercial building from person B.
Okay, a normal real estate deal.
But there is a specific purpose. Person A is buying it specifically to rent it out to businesses, and both parties know this. The seller knows this is the only reason the buyer wants it.
Yes. But while the sale is still pending, the city government steps in.
Oh no, what do?
They condemn the building. They declare it completely unsafe for any human to use.
Wow. Okay, let's analyze this. Is it impossible for person A to buy the building?
No. They still have the money in their bank account. They could easily just hand the money over.
Right. The act of buying is not impossible. Is it
No.
impracticable?
No, writing a check isn't extremely difficult or expensive.
So impossibility and impracticability do not apply here.
Exactly. But look at the purpose.
The purpose was to rent it out.
Right. And can they rent out a condemned building?
No, it's illegal. Nobody can go inside.
Therefore, the whole reason for buying the building is completely frustrated. It is completely pointless for person A to buy it now.
So because the Y is destroyed, person A can just back out.
Yes. They can rescind the contract without any penalty.
That is such a clean rule. Okay, listener, recap checkpoint 3. We are going to do a rapid fire comparison for the MBE.
This is how you tell them apart on the test.
If you cannot do the job at all,
Impossibility.
if you can technically do it, but it's extremely hard and ruins you financially.
Impracticability.
If you can do it easily, but there is absolutely no point anymore.
Frustration of purpose.
Boom. That triad is going to get you so many points on the bar exam.
Absolutely.
Okay, segment 4. We've talked about painters, landscapers, boats, and buildings. But what if we are buying and selling physical products? Does all of this change?
Yes, it does. This brings us into the world of the UCC.
The UCC. Let's define that in simple terms for the listener.
UCC stands for Uniform Commercial Code. It is a special, specific set of rules just for the sale of goods.
And goods means?
Physical things you can touch and move, like cars, computers, bags of flour, lumber.
So not houses and not services, just
Yeah.
physical product.
Exactly. And the UCC has its own version of impracticability.
And we have another mnemonic for it.
Yes. The mnemonic for UCC impracticability is CMB.
C and B. Imagine saying cats make biscuits.
I love that. Cats make biscuits.
So what does the C mean?
C means a contingency occurred.
Contingency is just a fancy word for an event, right?
Right. An unexpected event happened.
Okay.
M means the event made performance impracticable.
So the event made it super hard to deliver the goods.
Exactly. And the B is our old friend. Basic assumption.
Ah. Both people assumed this event wouldn't happen when they made the deal.
Yes. The non-occurrence of the event was a basic assumption of the contract.
Okay. C and B contingency occurred, made impracticable, basic assumption. But here's where it gets really interesting under the UCC.
It does. The UCC has a rule for when things are only partially destroyed.
Let's explain total versus partial. Total is easy, right?
Yes. Total is like common law. The specific goods are totally destroyed in a fire. The contract is discharged.
But what if, say I own a flour mill,
Okay, a flour mill.
and I have contracts to sell flour to 5 different bakeries, but my factory catches on fire and half of my flour burns up.
So you still have some flour, but not enough to give everyone what you promised.
Right. I can't fulfill all 5 contracts totally. What does the UCC tell me to do?
The UCC uses a rule called apportionment.
Apportionment. Let's translate that.
It means you have to divide what is left fairly among all the buyers.
Oh. So I can't just give all the surviving flour to my favorite bakery and tell the other 4, sorry, you get nothing.
No, you absolutely cannot. You must divide the surviving goods fairly. So maybe everybody gets half of what they ordered.
Okay, but wait. As a buyer, let's say I own one of those bakeries. I need 100 bags of flour to run my business today.
Right.
You show up with only 50 bags because of apportionment. Do I have to accept just a fraction of what I ordered?
No, this is the protection for the buyer. The buyer has the power to refuse the partial amount.
I can just say no.
Yes. You can reject the partial delivery and completely cancel the contract so you can go buy your flour somewhere else.
That is so fair. The seller has to try to share, but the buyer doesn't have to accept a useless amount.
Exactly. It's a very practical rule for business.
Okay, the UCC has one more practical rule here. Substitute transportation or payment.
Right.
So the factory didn't burn down. I have all your flour.
Great.
Our contract says I will ship it to you on a specific train. But the train workers go on strike today. The train isn't running.
Okay, so the agreed way of shipping is impracticable.
Do I just get to cancel the contract and not give you the flour?
No. The UCC says you must use a commercially reasonable substitute if one is available.
Commercially reasonable substitute, so I have to find some trucks.
Yes. You put the flour on trucks instead of the train.
And as the buyer, do you have to accept the trucks?
Yes. The other side must accept the substitute. You can't just cancel the deal because it arrived on a truck instead of a train.
Again, the UCC is just trying to keep business moving.
Exactly. Keep the goods flowing.
Okay, time for recap checkpoint 4.
Let's do it.
For the sale of goods under the UCC, remember, C&B contingency occurred. Made it impracticable, basic assumption. If there is a partial disaster, the seller must use apportionment, which means dividing up what's left fairly. But the buyer has the absolute right to cancel a contract if they don't want the partial amount. And finally, if the shipping method fails, find a reasonable substitute like trucks instead of trains, and the buyer must accept it.
That is perfect.
Yeah, right. We are on the final stretch, segment 5. We've talked about disasters and surprises. But what if nothing goes wrong?
What do you mean?
What if both people just look at each other and say, you know what, I just want to walk away from this deal?
Then we are dealing with the last 2 letters of our fire mnemonic, R and R.
Rescission and release.
Yes. Let's start with rescission.
Rescission means canceling a contract.
Yes, but it's a specific type of canceling. It requires returning any deposits or benefits already given. It's like rewinding time.
Right, so if I gave you a deposit, you had to give it back. We just mutually agree to walk away.
Exactly. The consideration, the legal value exchanged, is simply both parties surrendering their rights under the old contract.
I give up my right to sue you, you give up your right to sue me.
Exactly.
But the sources point out a huge trap here for the MBE. The third-party trap.
Yes, this is tested all the time.
What is a third-party beneficiary?
It's someone outside the contract who is supposed to benefit from it.
For example, a grandfather hires a builder to build a house, but the house is a gift for his granddaughter.
Right. The grandfather and the builder are the two parties. The granddaughter is the third-party beneficiary.
Okay. So what if the grandfather and the builder decide to mutually rescind the contract? They just want to cancel it.
They can do that unless the granddaughter's rights have already vested.
Vested. Let's define that.
Vested means her rights have become legally secured or locked in, usually because she found out about the house and relied on it.
Like, she went and bought furniture for the new house.
Exactly. Once she does that, her rights are vested.
And what happens if they try to cancel the contract after she buys the furniture?
They cannot. Once the third party's rights have vested, the original two parties cannot mutually rescind. They are locked in.
Wow. That's a great trap to watch out for.
Yeah.
Okay, that's rescission. What about the final R? Release.
A release is a written document showing the intent to discharge another party from a duty.
It's basically saying, I know you owe me, but I release you.
Right. But there is a massive MBE trap here regarding consideration.
Consideration being the value or money exchanged.
Yes. And the trap is the difference between the common law and the UCC.
We have a great mnemonic rule for this.
Yes, we do. The rule is C equals C and U equals U.
Let's break that down. C equals C.
Common law equals consideration needed.
So for a standard common law contract, like a service contract, you must give some consideration, some value or money, to release someone from a duty.
Right. I can't just write a note saying I release you. You have to give me something back, like a few dollars or a different item, to make the release valid.
Because common law equals consideration needed. C equals C.
Exactly. Now, what about the UCC?
U equals U.
UCC equals unnecessary or unsupported by consideration.
So for the sale of goods, NO consideration is needed.
Correct. Under the UCC, you only need a written waiver or renunciation signed and delivered by the aggrieved party.
Just a signed piece of paper. You don't need to give me any money.
Exactly. The UCC makes it very easy to just sign a release and walk away.
Because U equals U, UCC equals unnecessary.
Perfect.
Okay, recap checkpoint 5.
Let's review the R's.
Rescission is a mutual agreement to walk away and return to normal. But you cannot do it if a third party's rights have vested, meaning locked in. Release is a formal discharge. Remember, C equals C. Common law needs consideration. And U equals U. UCC means consideration is unnecessary. Just use a signed writing.
That is exactly right.
We have covered so much ground today. Listener, you are doing amazing. Let's do one final rapid-fire master recap of the whole FIRR mnemonic to lock it in your brain for the exam.
Let's bring it all together.
F, frustration of purpose. The job is easy, but the why is gone, like the condemned building. I, impossibility. Nobody in the world can do it. Use IDI, illegal, destroyed, or incapacitated. I, impracticability. The job is possible, but totally ruinous. Use UBINN, unforeseeable, basic assumption, impracticable, not at fault, no risk borne. R, rescission. Mutual agreement to cancel, watch out for vested third parties. R, release, discharging a duty. C needs C, U needs U.
That is the master blueprint. You have all the pieces.
It really is. Before we go, do you have a final thought for our listener?
I do. If we connect this to the bigger picture, contracts are often described as ironclad promises. They are supposed to be unbreakable. But looking at these doctrines, impossibility, impracticability, frustration, we see that the law actually builds escape hatches into our agreements.
Escape hatches.
Yes. To account for the unpredictable chaos of human life. Floods, laws changing, sudden accidents. It makes you wonder, is a contract really a guarantee of the future? Or is it just an expression of our best intentions in the present, hoping nothing crazy happens?
Wow. That's a really profound way to look at it, just doing our best against the chaos of the universe.
Exactly.
Well, listener, we hope we brought some order to that chaos for you today. Thank you so much for joining us on this deep dive. Keep practicing those mnemonics. We know you are going to do incredible things. Best of luck on the MBE.